Good morning, everybody. This is a meeting of the Boulder County Commissioners. It is April 29th, 2021. All three commissioners are here. And here today we're for a public meeting. We won't have public testimony, but just informational on COGC, Colorado Oil and Gas Conservation Commission Mission Change Rulemaking Overview presentation to the Boulder County Commissioners. Kim? You're muted, Kim.
Sorry, my internet cut out for just a second, so I didn't hear you pass that on to me. I'm Kim Sanchez, Deputy Director of Community Planning and Permitting, and as Commissioner Jones said, that we are here for a presentation from the COGCC Commission Chair, Jeff Robbins, and he is planning on giving an overview on the overhaul of COGCC's rules that went into effect pursuant to SB 181. So Jeff, I think it might be great if we could start off with just some quick introductions. We do have two new commissioners, and so I will hand it over to them to introduce themselves to you.
Okay, looks like it's taking Marta a second to get unmuted. So nice to meet you, Jeff. Although we may have met, I'm not certain about that. Claire Levy, I'm a new county commissioner. I live in Boulder. I did have a stint. I served a sentence in the state legislature in the House in 2007 to 2000 through the 2013 session, and during that time. Now head of Department of Natural Resources, Dan Gibbs, actually ran a bill to try to change the mission of the COGCC to balance the interests. And I actually was very heavily involved in trying to help him get that passed. And then I have the misfortune of being a lawyer. And so I was on the Committee on Legislative Legal Services, which had jurisdiction over the rulemakings that were done to, there's a process where you can challenge them and try to invalidate them. And then they have to go to the legislature. Anyway, long story short, prior to 181, I had a lot of experience with kind of the jockeying around how these rules were interpreted. And so it's very nice to be able to pick up the conversation again with a totally remade mission. And I'm very eager to hear what you have to tell us about how the COGCC is interpreting that mission and what our opportunities are as county commissioners to weigh in on that.
Nice to meet you.
Thanks.
Good afternoon, Jeff. My name is Martha Lochamin. I'm newly elected, as Kim said, commissioner here in Boulder County. I represent District 2 and live in Longmont. Thanks for your presentation today.
Thank you. With that, Kim, should I get started?
Yeah, please go ahead. I will also note that we have a few other Boulder County staff that are also panelists in this meeting. And so it's mostly for purposes of getting the commissioners acquainted with the new rules from your perspective. They've been briefed by county staff as well, as Kate and I both were active participants in the rulemaking. But we may have questions from a few other people aside from the commissioners in the end.
Excellent. Well, first off, thank you all for the time to be with you this afternoon. We at the commission, myself and Commissioner Messner, who is a Gunnison County Commissioner, have offered up the opportunity to speak with local governments, and we were thrilled to hear that you wanted to hear from us, and I quickly gobbled you up and took it upon so that I would be able to present to you, and so I'm happy to be here today. I'd like to start with a little bit of background about myself, because the commission, or at least two of the commissioners, may not know my background as well, and maybe some of the staff and maybe people listening in. I have been was a practicing attorney in out of Durango, Colorado since January of 1996. And one of my clients from the beginning was La Plata County, and my firm serves as outside counsel to La Plata County. And in that regard, I was the attorney to assist the planning department which also meant I was the attorney assisting the oil and gas division of the planning department. And La Plata County in the late 90s and early 2000s had an extensive boom of oil and gas coal bed methane development. And the community was one of the first to attempt to regulate oil and gas land use aspects. And I was involved early on in those discussions, debates, and lawsuits with the Colorado Oil and Gas Conservation Commission, because the then commission did not take friendly to local governments trying to exercise authority. La Plata County's case went to the Supreme Court. It was a little before my time, but it established that local governments do have authority to regulate, but that authority could be preempted if the state regulated in a similar area. So I was in charge early on in trying to balance that and trying to empower my community to be able to regulate oil and gas from, again, the late 90s, early 2000s. Later in my career, in the last 15 years or so, I've worked with a number of communities across the state to assist communities in that same regard. And again, dealing with and balancing the preemption test where the Oil and Gas Commission could negate what local governments could do. One of my favorite clients was your community. I worked with Boulder County in 2012 and 2013 and assisted the staff and the then commission and planning commission in revamping your oil and gas regulations from what was, I think, like a 6-page regulatory body to what I believe at the time that you adopted them were the most protective regulations that were still, legal and protective. And so you did a great job. All along the way, I've been learning the area around oil and gas development and local governments, and it was a pleasure working with you back in 2012 and 2013. After that time, I worked with multiple Front Range local governments, and the story ends or begins with me becoming acquainted with then Representative Jared Polis, and I provided legal counsel to Representative Polis about oil and gas development because many of his constituents were interested in that for 5 or 6 years. He asked me to serve on the 2014 Hickenlooper Task Force on oil and gas development, which I spent a year working hard on that, which was mostly not successful in my opinion. And after Governor-elect Polis was elected, I got a call to come visit with him in Boulder, and he asked me to serve as director of the Colorado Oil and Gas Conservation Commission. So that is what I started doing in January of 2019. The first few months are a tremendous blur because I spent a lot of time in the Capitol working on behalf of the Polis administration in the creation of SB 19-181. That passed on April, and Governor Polis actually signed it on April 16th. And now I can get into my presentation. Now you have a little background about how I ended up in this job that I wasn't necessarily lobbying for, but I'm having a wonderful time doing it. And I think we're making great inroads to the state of Colorado with regard to the act that was passed and how we are implementing it, and also our newfound relationship with local governments, which I also will get into. So I'm going to give a brief overview of SB 19-181, and then I'm going to give an overview of the implementation that has occurred for the past 2 years as at the Colorado Oil and Gas Conservation Commission. So the act was signed April 16, 2019. It created a new mission for the commission. The commission historically was required to foster oil and gas development, and that connoted a sense of promoting oil and gas development. The new mission is that we will regulate oil and gas development in a manner that protects public health, safety, welfare, the environment, and wildlife resources. Previously, our regulation of oil and gas development was balanced against everything needed to be technically feasible and economically practicable. Those words were removed from the act, and instead our regulation of oil and gas development in a protective manner must be reasonable and necessary. So that's the big theme for the COGCC. We were dealt about 8 different rulemakings, and we took that theme, and as I'm going to go over today, we then revamped our oil and gas regulations in a manner that is consistent with this new mission, from fostering to regulating in a manner that's protective. The second main theme of SB 19-181 is it provided express authority to local governments to regulate surface impacts and siting and land use with regard to oil and gas development. As I mentioned, previously local governments had authority to regulate, but that authority could be constrained whenever it collided with the authority of the state agency, and then the state agency would preempt the local authority. Well, SB 19-181 removed preemption, provided express authority to local governments, and established that local governments could regulate land use, surface impacts, and siting in a manner that's more protective than the state. So we look at what we do at the state with regard to areas, and then we look to local governments who can use their authority without fear of preemption and in a manner that's more protective. The authority that's granted to local governments is discretionary. In other words, it's not mandatory that every local government regulate oil and gas development, but if they choose to do so, they can now do so. The SB 19-181 reconstituted the commissioners twice. We went to a new, more balanced volunteer board that was seated in May of 2019, and their term was up in June 30th, 2020. And then on July 1 of 2020, the commission was reconstituted again, and now permanently. And so we now have 5 permanent, full-time professional commissioners. So this is our all day long, everyday job. These guys were volunteers, and they would show up about once every 6 weeks and do their work. These guys did a phenomenal amount of great work, but the legislature in its wisdom decided that a full-time commission made more sense in 2021, 2020 and beyond. And so that's where we are now. So I served as director of the commission from January of 2019 to June 30th of 2020. And when the new board was seated, Governor Polis appointed me to be chair of the new commission. Each one of us has a different seat. This is Bill Gonzalez, and he was a landman with Anadarko and Occidental, and he fills the industry seat. This is Priya Nanjappa, and Priya has an extensive background in wildlife management and wildlife resources, and she serves the seat that is wildlife. This is John Messner. He's a former Gunnison County Commissioner. John also served on the Volunteer Commission, and John serves the seat that has local government and land use expertise. And this is Karen McGowan. Karen had been at CDPHE for a long period of time. She was the deputy director of CDPHE, and she sits in the seat that is for public health. So the new commission has industry, wildlife, local government, land use, public health, and then the fifth is the seat that is someone that would provide or has extensive experience to provide good knowledge and helpful decision-making. And so that's me, I suppose. So that's the overview. Now we'll go into some of the rulemakings that we did at the Volunteer Commission. So we started with the Volunteer Commission, who were seated through June of 2020, and they undertook the 500 series, which was an administrative process series. They undertook updating the flow line rules, which are the pipelines that the COGCC regulates, and are generally the flow lines or the ones around the oil and gas locations. They revamped our wellbore integrity rules. These are the rules around protection of groundwater with regard to oil and gas development. And then the Volunteer Commission started but did not finish the mission change, which is where we'll spend most of our time this afternoon. So this is the mission change rulemakings. Again, as I mentioned, we have a rule book that's about, a couple 4 inches thick. And we decided that with the fundamental alteration in the mission change rulemaking from 181, that we needed to go through and look at all of our rule sets with this new mission in mind. And so it gave us an opportunity to fundamentally restructure, retool, get stakeholder feedback, et cetera, with regard to all of our rules. So I want to talk a little bit about process. Ms. Sanchez and Ms. Burke are very familiar with this. You were well supported in your involvement with our mission change rulemaking. But I really wanted to have a commitment to transparency and public engagement. As a former local government lawyer that practiced before the commission on behalf of my local government clients, at times I felt that I wasn't heard as well, or did not have standing to be able to participate as much as I felt should be apparent within the Colorado Oil and Gas Commission. So I took that history of working on the outside looking in, and now that I'm on the inside, I wanted to really commit to transparency, public participation, engagement, and information. So to implement these rules, we took over 2 years. We started with a mission change white paper, which was notions around what does it mean to move from foster to regulate in a manner that's protective. We then published what I called straw dog rules, or concepts, things for people to take stabs at. We took initial public feedback and additional public feedback. We posted the rules in March. We posted a second set in June. We had party pre-hearing statements, party response statements, and we opened it up for stakeholders to be involved, and they took us up on that. We had over 90 parties participate in our mission change rulemaking. That's not 90 individuals, that's 90 groups. And we conducted over 181 hearing hours of discussion and deliberation. Ironic that it's Senate Bill 19-181 and the number of hours, but for every hour that we were in hearing, I know your staff would agree, there were tens of hours to get ready for hearing. We had 122 witnesses, and we started this way, but starting in March, as with most of us, we ended this way. And so we did our hearings through Zoom. And frankly, I think, and you may have felt this as well, I think that it provided greater public participation because people didn't have to drive to Denver, find a parking spot, find the building that we're located in, and go through that. Instead, they could Zoom in, they could share screens, they could share their witnesses, we could participate via the virtual format. And so I think it was actually helpful to the transparency and public engagement that I was hoping to have. So in some overview, I believe that we did a fair job of discussing the key issues identified in SB 19-181, including the redefining the relationship between the commission and local governments, defining and providing for cumulative impact analysis and data gathering, establishing an alternative location analysis for proposed oil and gas wells, creating siting requirements and setbacks from schools and homes, stopping flaring and venting on a phase scale, ensuring wildlife protections, and as I said, essentially reorganizing, modernizing, and streamlining the rules by updating language and grouping together topics to ensure easier accessibility and better clarity. So with that, let me get to my next slide. These are the rules that we updated. So this just sort of gives you kind of an overview from the 200 series to the 1200 series. And then I was going to go into a little more detail for each series so that you can get a sense of what the changes were at the commission. So the 200 series are our general rules. One of the things that we did here was we upped the ante with regard to transferring of permits. Oil and gas wells, when they first start out, are very productive. And then over the course of time, they become less and less productive. And one theme that we've seen is that as oil and gas wells become less productive, larger operators can at times transfer those wells to different operators. And this was a ability by right before. That's no longer the case. And we do now scrutinize the transfer of permits so that we ensure that if a permit is going to be transferred to a new operator, the new operator has the financial wherewithal, the operational wherewithal to ensure that the well will be operated and then plugged and abandoned responsibly at the end of the life of the well. We streamlined and modernized processes for handling confidential information, and we worked on due process for operators. We basically are taking advantage of the full-time commission to allow the director to create immediate orders if necessary to protect public health, welfare, safety with an expedited appeal to the commission. Our 300 series is our permitting rules series. Here, as I mentioned, we established and tried to establish regulatory relationships between local and state governments. Again, the SB 19-181 provides express authority to local governments, and it allows local governments to be more protective. We have lots of different local governments across the state with lots of different viewpoints about how it may or may not want to work with, be involved with the state agency. And so we tried to create within the rules abilities for local governments to look to the state as a ally or an assistant with regard in particular to downhole or technical concerns. And so that's one of the main themes that arises out of the 300 series. Second, we created for the first time, our agency will incorporate environmental justice as a consideration for the siting of a facility into its rules. Third, we created a commitment to gathering data and partnering with CDPHE on cumulative impacts, including gathering data around greenhouse gases. Fourth, we created the alternative location analysis. This is a new process that allows commissions, operators, and local governments to determine how best to avoid impacts to a wide range of resources. Historically, the commission did not require operators to look at different locations. Historically, the commission would receive a proposed location, and then they would determine whether it was approvable, and they would mitigate that location with best management practices and conditions of approval. Now we have a real ability to require the operator in certain circumstances to look at not just the one location that they may prefer, but to look at and define and establish the best location with the least amount of impacts. We're seeing a lot of, we're seeing some other local governments doing this as well. You have that authority. And so we want to collaborate and work with you for those local governments that are doing this. And then finally, we revamped what used to be our comprehensive drilling plan, and now we call it the comprehensive area plan. And this incentivizes and encourages the comprehensive area plan as a tool for planning and minimizing adverse impacts by looking at a large area as opposed to just looking at one-off well locations. In the 400 series, we expanded the rules to protect public water systems. In particular, we protect shallow, vulnerable groundwater resources to protect and help Colorado's water resources. We adopted a statewide prohibition on certain chemicals, additives, and hydraulic fracturing fluid. We upped the ante with regard to notifications, with regard to timing and the recipients of notices. And you may now be aware that Boulder County is receiving more notices of activities that are on site within oil and gas locations. And that was because local governments desired the opportunity to opt into more notifications. And then we upped the ante on noise and nuisance. We created new, more robust noise, odors, dust, lighting standards. We allow the director to take the action to require the operator to mitigate the issue. And the director now has the authority to stop operations for noise, again, with appeal to commission. We adopted new standards for low frequency noise. This is the vibration type noise. And we ensure that the director and commission have discretion to apply lower noise standards for both high frequency and low frequency noise where necessary. Our 500 series is our rules of practice and procedure. And the big theme here is we expanded public access to commissioners. Again, we now have the commissioners as the deciding body for oil and gas development. It used to be that the deciding entity was the director of the commission as an administrative action. Now all new oil and gas development will be decided by the commission. We expanded the definition of standing greatly. It used to be fairly narrow, and standing is who has a right to come up here before the commission on an oil and gas development plan. And again, it used to be fairly narrow. Now we have ensured that all local governments and affected residents have an opportunity to be heard by the commission. We created a new term called the proximate local government. So it used to be that just the local government that had jurisdiction over the oil and gas location had standing, but now if you're a next door local government, you likely also will have standing. And we expanded public access and information. We're now making our notices and our brochures available in different languages so that communities that are not first English communities will have an ability to understand what's happening at the commission. The 600 series is our safety and facility operations series. In it, we upped the ante with regard to protection of public health, safety, welfare, the environment. And here we also expanded protective setbacks and siting requirements. Our setback and siting requirement was 500 feet with exceptions. We now have that at 2,000 feet. It is not a hard setback. It is a setback that includes off-ramps. So if the operator desires to drill a well that is closer than 2,000 feet, it would need to prove to the commission at public hearing one of these four things. The well location is within approved comprehensive area plan. So again, it's part of that. We've already looked at it and we know that it's more protective because we're looking geographically and globally at the area. Or if the equipment that has the greatest noise and emissions are located more than 2,000 feet, then the well can continue to be located closer. And then if the commission finds after hearing that companies have taken substantially equivalent protections for public health and safety, that gives the operator the onus to prove that even if it's closer, it's still going to be protected. And then we honored the rights of property owners and tenants. If everyone within 2,000 feet says it's okay, with informed consent, and we've created a robust informed consent protocol that ensures that if someone's signing the document, they know what they're signing, then the well could be located closer. So this series received a lot of debate and dialogue, but it ultimately was adopted unanimously. All of our rules were adopted unanimously by all 5 commissioners throughout the work that we did. The 800 series is our underground injection well series. We regulate underground injection wells to ensure they're protective. And essentially the underground well rules that we have now are gold standard, best in the nation to strengthen protections for Colorado's groundwater, because that's the thing that you're most concerned about. In the 900 series, this is our environmental impact prevention. We adopted best in the nation standards to protect public health, mitigate climate change, and prevent the waste of a valuable natural resource by phasing out and prohibiting routine venting and flaring of natural gas. This will still be allowed in certain one-off situations, but generally speaking, we now will not allow routine venting and flaring of natural gas. The other important element of the 900 series was the creation of a new approach to evaluate potential cumulative impacts of oil and gas development. We created a Cider database, and we are going to get such data from operators across the state, and we're going to daylight that data yearly, and then we're going to use that data to influence next steps around how we can ensure the protection against cumulative impacts of oil and gas development. The 1200 series involves wildlife, and here we required avoidance of Colorado's most critical habitats through specific habitat protections, as well as the requirement for alternative location analysis in order to protect wildlife. We bring into the commission its new authority to require compensatory mitigation requirements as directed by the Act. We expanded rules to protect aquatic habitats for both iconic, native, and economically important aquatic species. And then we implemented the EDO order concerning big game winter range and migration corridors through minimization of disturbance in big game winter range and migration corridors within our rules. So that's an overview in about 25 minutes of what we've been doing. The new rules went into effect on January 15th, 2021. They were adopted on November 23rd of 2020. And between November 23rd and January 15th, the staff at the commission, we have 140 some odd employees, they were awesome. They revised 11 forms that are part of our computer database, and they created 3 new forms. To put that in perspective, the best that they'd ever done before was the creation of 1 new form with a rulemaking rewrite. So, and we're very data intensive, and everything is online. So the commission is now able to receive new permit applications. One thing that I wanted to alert you to, there's always been a lot of concern about the backlog of oil and gas permits that were pending at the commission. And we had over 3,800 well applications and close to 350 new location applications that were pending when we turned on the new regulatory regime. We gave operators until March 1 to notify us which of the current pending well location and well applications they desired to replace. And we will be removing the rest of those from the backlog. So essentially, we're going to be moving away from a backlog of oil and gas wells to a new replacement oil and gas wells and well locations that operators want to move forward with. And then we have more work ahead of us. SB 19181 had 3 additional rulemakings for us to look into. One was around financial assurances. We were directed to look into increasing financial assurance for inactive wells and for wells that were transferred to a new owner. SB 19181 informed us to look into the creation of a per well location specific financial assurance account to cover all costs of plugging, reclaiming, and remediating a well. So the account would move with the owner of the well, and the creation of a pooled fund for orphan wells where no operator is the responsible party. So we're looking at those things. We're also looking at basically everything around bonding and everything around the orphan well program that we have. We opened up an informational docket about a month and a half ago. We anticipate publishing proposed rules in late May, early June, having the rulemaking over the summer and culminating with a rulemaking in September. We also were told to address worker certification. This has to do with ensuring OSHA and API compliance for workers in the field. And then we were informed that we could have permit fees for oil and gas wells. The previous statute said that we could have permit fees, but the fees were capped at $200. Now there is no cap, and we're allowed to have fees, and we'll be looking into that probably after we look through the financial assurances rules. And that's my overview of COGCC for the past 2.25 years. I would just want to close by saying that, we hope to be looked upon by other local governments across the state as an agency that you can turn to, that you can partner with, that can assist you in your regulatory involvement of oil and gas within your jurisdiction. The folks that work at the COGCC have wholesale bought into what we're doing. It's great to work with this group of great state employees. I'm happy to take any questions from you. And again, thank you for the time with you this afternoon. And I will stop my screen share. Here we go.
Great. Well, thank you. That's a great presentation and a quick summary of a whole lot of work to get us where we need to be to have local control around oil and gas development. I do have just a couple questions. You talked about in the Series 500 rulemaking about proximate. Could you talk about that a little bit more, talking about neighbor communities and what that might mean for us in Boulder County?
Yeah, so and I don't have the specifics before me right now, but basically the theme there was the old regime allowed some standing to the relevant local government. That's the local government that is the local government with jurisdiction over a proposed oil and gas location at the state agency. That government could come in and participate in limited circumstances. We created additional involvement by the government with jurisdiction in the new rules. And then we also recognized and understood that neighboring local governments at times deserve to have standing as well to come in and participate in the local government or in the COGCC process. I know from being a local government lawyer that was a very important piece to this. I represented, just as a way of an example, Adams County was one of my clients when I was back as a practicing lawyer, and the city and county of Broomfield decided to suggest to the commission that the best place for oil and gas locations was right on the border of Adams County. And Adams County wanted to participate in that. And I tried to participate on behalf of Adams County as their attorney. And we were politely informed that, no, you're not the jurisdiction with the government jurisdiction. And so we tried to undo that hypothetical. So now you will be able to be more involved with the oil and gas permitting protocol that will happen at the state for locations that are near your borders, but that are not within your borders. And that's important for many Front Range local governments.
Can I piggyback on that one, Marta?
Sure.
So just hypothetically, if Weld County were to put a well right on our border, what powers does that confer to us?
You would have the ability and authority to be a participant in the oil and gas development plan at the state, and you could bring the concerns that you have to the state. You could ask that the state require an alternative location analysis to determine the best location if it meets some of the requirements for alternative location analysis. And essentially you can participate at the state. And so that is what a lot of local governments were advocating for. And I think that's where the commission felt that made sense given our new mission and given this new interrelationship with local governments.
Great. Yeah, that's interesting. I hadn't heard that detail of what that would look like. So appreciate that. The other question I had was on the Series 900. And now I'm not going to remember exactly what was on the screen. I just wrote down Cider.
Oh, yeah. Cider is an acronym, and unfortunately, I don't recall exactly what it stands for, but it is the data gathering requirement for cumulative impacts that we're going to require.
That's what it was, the cumulative impact.
Mm-hmm. And so we're going to require all operators to provide that data in a format that is going to be publicly accessible on a well location by location basis and annually. And then we plan on using that data in concert with CDPHE to review and analyze and anticipate and determine what are the next steps. What kind of cumulative impacts are we potentially seeing? And what are the next steps to ensure that we are addressing potential cumulative impacts from multiple locations in and near people?
Okay, and I was just trying to clarify if that process has already been started are you already monitoring some of that, air quality or whatever it might be to determine as a baseline, or you're saying that that's now going to be able to happen and we should look for data when?
By the end of the year, we would get our first set of data.
Okay.
We also, Commissioner, are on a well location by well location basis using our new authority to require air emissions monitoring, which also is getting data. AQCC recently adopted rules around air emissions monitoring as well. And so there's a lot of data that's being developed, and we need to cross-pollinate that data so that we're able to use it as we start to get enough of that data to be able to look at cumulative impacts and determine next steps. The commission was pretty honest in that it felt like it needed to do data gathering first, but that this is not the end of cumulative impacts analysis at the commission. And that will be an evergreen sort of approach with the commission, continuing to look and relook at those issues.
Okay, and that only the last piece I had around the cider was just, you said that information will be available on your website. And is that going to be information accessible for folks so that we can maybe multi-layer maps, geographical data, when we talk about environmental impacts, but also environmental justice? Will that be info open for folks to be able to utilize?
The conceptual answer is yes. I don't know exactly how that's going to materialize. Our OIT folks need to sort of figure that out. And so how one accesses it and how much of it is downloadable or otherwise, I don't know the answer to that yet, but that'll be developed this year.
Okay, great. Well, I appreciate that.
So I don't actually know where to begin. I don't think I have any real specific questions on any of the rules. You know, you've done just a phenomenal amount of work, very, very technical work, to activate the authority that you were granted, and it really is impressive how much you've been able to get done, and I appreciate how technical it is, and I'm so glad that there is now a full-time professional commission, because it's just too much for volunteers to do and to actually, you know, be a counterweight. So, you know, this is all good stuff. One thing I think I'm wondering about is, you know, as we and you, the commission, just live with these rules for a while and see what works, what doesn't work, where did we, you know, where might there be holes or ambiguities or anything of that nature. You know, there's always a learning process. Do you have now inherent authority to open up new rulemaking processes, to modify rules, or do you need to go back to the legislature and get additional rulemaking authority? And I guess maybe that has to do with whether you're a type 1 or type 2 agency or something completely different.
No, I believe that the authority that was granted to us, which was broad authority to regulate in a manner that's protective in a reasonable and necessary manner, I believe that if we see our rules and see that there are needed or reasonable or necessary changes, that we would have authority to republish new rulemaking without having to go back to the legislature. Because the legislature established kind of the broad collective goal and said, you now need to go implement it and make sure that you're reaching that goal. And if commissioners don't believe we're meeting that goal, or others, then I believe that we do have the ability to go back and reassess an area to ensure that we're meeting that broad goal of regulating in a manner that's protective. So I think we've absolutely got the authority to redo or adjust or realign if necessary into the future.
Yeah, okay, that's good to know. And I'm not sure how to ask this question in a coherent way, but you know, you're both generating a lot of data, you're using a lot of data, and you know, you need to take a lot of data into account. There's CDPHE over here, the Air Quality Control Commission, the pollution, what's the pollution?
The waste management.
No, I'm gonna think of another. But so how much are you able to, and I think you were addressing this maybe towards the end of your presentation, how much are you able to integrate with CDPHE and the information and data that they have and the air quality monitoring that they do?
That's a great question, and it's a great work in progress. We work very closely with CDPHE. You know, they are just recently starting this additional data and emissions monitoring. And so they're going to be getting data. And, I've got, one of our commissioners is sort of dedicated to being the liaison to CDPHE. We have staff that work with CDPHE. It's a work in progress, and we are hopeful that we will be able to, again, sort of cross-pollinate and use their data, they use our data. We all work together on these issues, in particular around cumulative impacts. So it is something that we're doing. I can't say that we've got it dialed in just right just yet. We're just now getting data. They just adopted rules that will generate additional data, but we do all know and believe, and it's our great desire that we will have that so it's workable across agencies.
Yeah, it was the Air Pollution Control Division that I couldn't think of. And then lastly, I don't know if you touched on this, and it's been a little while since I read Senate Bill 181, but the issue of water consumption in the fracking process, and the origin of the water, the discharge of the water, cleanup standards. Do you have, is that within the jurisdiction of the COGCC, or is that not?
Much of that is within the jurisdiction of COGCC, and we did up our standards. So we now have water management plan standards. We now have an ability to get information about where the water's coming from, whether it's being recycled, how it's being cleaned. The 400 series really dives into the technical details around that. And as the commission, as the agency that will be determining whether to grant or a permit or not, it will be looking at the issue of water through the same vision and prism of, is this protective of public health, safety, welfare in a reasonable and necessary manner? So that prism gets placed on water as well.
Well, it'll be interesting to see how far that goes. That's a broad analysis, to help protective of public health, safety, welfare. Water consumption, would that be within your purview, or I mean, where would you?
Yeah, I'd have to go back and look at the specifics of where we landed with the 400 series, and I'm happy to get that information to you, Commissioner Levy. If you could I don't want to off the cuff say something that's not directly in line with my technical folks that help develop up those standards.
Yeah, okay, thanks. No, I appreciate it. That's all I had, thanks.
So thanks for the presentation, Jeff. I was just sitting here while you're going through those rules, thinking of all the slogging. I did, 19 bills as co-prime or prime sponsor of in the Senate and in the House, starting in the House actually. And 2 of them were mission change bills, if I remember right. But it just is so much better. And just going through those rules and participated in rulemakings too, as testifying. But so I'm really happy you guys got as far as you want. Boulder County always wants you to go a little farther, which we're nice people, as you know, and so it'd be great if you could. Into that data and the cumulative impact, it's always driven me crazy that oil and gas is kind of different in that they come in little pieces and do a lot more, can get away with a lot more than somebody if came in with one large permit. So if you could really make that work, that would be great, especially, with our ozone problem and our exceedances and all that stuff you're very familiar with. And this is mostly editorial comment, I apologize. The other thing is, for years, every permit was approved. They might have been modified, but they're all approved. And I'm hoping this commission says no at times. A good example is that well site near Bella Romero and Greeley. That was criminal. As far as placing it and where it was, and with the kids just on the playground next door. And I visited the site once, and it's just wrong. So I'm hoping you guys will be willing to say no. And have you said no yet? And do you plan to?
Do you plan to?
Yeah,
Well,
That was not very professional of me.
I'll try to answer the question in a manner that I can. First, Commissioner Jones, thank you for your leadership while in the legislature. A lot of the ideas that percolated around found their way into 181, and that was because of a lot of trial and effort. So I want to thank you for that. Two, we specifically built into the new regulations denial and the ability for denial. It was there before, and I'm not going to go back to historically what had happened. I tend to agree that generally a well would come in and it would be approved, and the difference would be what was the level of best management practices or conditions of approval. But we now have denial built in. We now have this ability to require alternative location analysis. We now have this more robust regulatory approach that ensures if it's approved, it must be protective. And so we'll see. We've not had a new permit come before us yet. So we've had a number of them are working their way through the systems. I think we'll probably start seeing permits in July at commission level. And I look at my fellow commissioners. I know of myself that we will apply the new rules as they were meant to be applied and approve oil and gas locations if we find them protective, but not necessarily approve if we don't find that they're protective under our new regulatory regime. So I look forward to moving this forward. Hopefully that answered your question.
Yeah, it's a new day, and I hope you guys exercise that authority in situations where it just doesn't make sense to do something. And by the way, you mentioned the Senate Bill 181, which Steve Finberg and Casey Becker were great in getting across the finish line. Before I left, right before I took this job, I took 4 bills and worked with Tom Morris and advised them and sent them to Casey and Steve. I said, if I were king, this is what I would do. And part of it is in there, but it's because Tom Norris knew to put it in there. So it was a bit satisfying. It was really satisfying actually to see that happen. And they did a masterful job with bill sponsorship. So anyway, it's a new day for the commission, and I'm happy to go in this direction. Bottom line, being protective of people is the bottom line, and I'm hopeful and thankful that you are working to do that. And let them change it to hard cider, by the way.
Sounds good.
Kim, did you have anything, or Kate?
I do not. We just wanted to make sure that you got the information that you might want to hear from COGCC directly, and staff is happy to follow up with you on any other questions that you might have. But thanks, Jeff, for your time today.
Yeah, and I wanted to
you.
thank you for spending an hour with us and for putting the presentation together and just walking us through what your process has been. It really is impressive what you've been able to do. And Matt, to your question about do you plan to deny any permits in the future? And I laughed, and I'm sorry. But a serious comment to that though is, with having really good regulations and a really good review process with a lot of scrutiny and a lot of professional resources available for that scrutiny, hopefully we'll get better applications if there is such a thing. I mean, which I think there is. So it maybe we won't see denials, but we'll see much more responsible oil and gas development, which after all is what the point of the bill was.
Yeah, no, I can't agree with you more. I do think that is what is happening, and what will happen is there will be smarter locations, smarter applications, more protective proposals, and that's going to go across the state. That's not just for the communities that regulate vigorously, but that's equally applicable because our regs and rules apply across the state of Colorado. And so that is actually what I sort of foresee happening, rather than, deny this, deny that. I think we're going to see smarter and better proposals from the outset. And I'm looking forward to this new next step. We were told to regulate in a manner that's protective. That means that if it's a good location and it's protective, then it ought to be approved. We'll move forward with it. And hopefully that will have this effect that you speak to, Commissioner Levy.
Yeah, and I have one last thing is thanks for listening to Kate and Kim and everybody else who works on these things. They work hard at it, as you know, and I think looking at the work they've done great work and very helpful in trying to figure out the challenges you have. And also say hi to John Messner for me, if you will, please. I got to know him before he went to the commission. So.
I will certainly say hi to John Messner, and I echo your words with regard to the work of your staff. Ms. Sanchez and Ms. Burke did yeoman's work. At times, I know they were frustrated with me and with the commission, but that's part and parcel of getting to the right spot. And your community was very helpful in ensuring that the commission, did land in the correct spot as mandated by 19181, and we were thankful to have them as participants.
Yeah, great. Thanks for being open. It's not open, right? Not over yet. So, Anything else, Kim or Kate, before we wrap this up?
Nothing from me.
Okay. Well, thanks, Jeff, and thanks everybody for being on.
Thank you.
I'm
Thank
surprised we didn't have more people watching, but oh well. It's recorded.
Bye-bye.
Bye-bye.
Yeah.
Thank you.
Okay, bye-bye.
Bye-bye.
Bye. Thanks, everyone.
Thank you.